the TCO and the DSA work because they work together.
And now actually we have a lot of questions after the DSA came into force if we still need the TCO or if we need both. And I hope that we can really show in this podcast today that yes, we do need both.
Hi, and welcome back to the Tech Terror Takedown podcast. I'm your host, Sophia Rothut, researcher at LMU Munich, working on the EU-funded TAPE project. Today, we're diving into a topic that is shaping the online space, the European regulatory landscape, aka the interplay between two major EU regulations, namely first, the so-called Terrorist Content Online, or TCO Regulation, and second, the Digital Services Act, or DSA. The TCO regulation, as we've discussed in previous episodes, focuses on combating the spread of terrorist content online. Meanwhile, the DSA sets out a broader framework to regulate digital services across the EU. To help us unpack the differences and synergies between these two key pieces of legislation, we have two guests joining us today. I'm thrilled to welcome back Friederike Wegener, who works at the European Commission at DG Home and is an expert on the TCO regulation. You may already know her from our third episode, which is a deep dive into this regulation. Welcome back, Friederike. Happy to have you again.
It's great to be here again. Thank you for having me.
Our second guest is Martina Maiello. Martina works at DG Connect as a case handler for the enforcement of the Digital Services Act. With her background in international law and security policy, she focuses on illegal content and the protection of minors online. And I'm very happy to welcome her as our expert for the DSA today. Thank you so much for joining us, Martina.
Thanks a lot for the invitation, Sophia.
Let us begin by setting the stage for our listeners. Could you share with us the main motivations and goals behind the TCO regulation and the DSA? Since both are legislative measures from the EU aimed at regulating online services and combating harmful content types, how do they complement each other? Let's maybe start with the TCO point of view, Friederike.
Sure. I think, first of all, it's really important to understand that both regulations are there to hold the platforms accountable for the content they host on the platform. But then they're also very different and indeed complementary, as you say. The TCO, the Terrorist Content Online Regulation, is really specifically focusing on terrorist content. We call it, so to say, a lex specialis. And the idea here is that platforms are accountable and they have to address terrorist content so we can prevent it from being spread, so that propaganda is not disseminated, radicalization doesn't happen, recruitment doesn't happen, or any other type of terrorist activity is not facilitated. Potentially, platforms also have to take specific measures to really prevent that their platforms are exploited for that misuse. And then you ask for the motivations, where does it come from? In 2014, 2015, we really saw the terrorist organization Daesh, or Islamic State, rising, and with that a lot of clear-cut terrorist content, such as beheadings, on mainstream social media platforms. Back then, so in 2015, the EU created the EU Internet Forum, that's our public-private partnership, to work jointly with the member states and tech industry and other stakeholders on a voluntary basis to prevent this content from spreading online. And there really we had some successes, but it also became clear that we do need regulation, mainly for three reasons. First of all, because there were platforms that did not want to cooperate, that did not want to do voluntary efforts to prevent this content from being online. So we really needed to have measures in place to address this. Also, we wanted to harmonize the approach across the European Union and then provide a clear legal basis for tech companies and for law enforcement to make sure that what we do is based on law and we safeguard fundamental freedoms. So the idea really was to enshrine the concept of what is illegal offline is now also illegal online. And now actually we have a lot of questions after the DSA came into force if we still need the TCO or if we need both. And I hope that we can really show in this podcast today that yes, we do need both. And I think one great example to clarify why and how was after the 7th of October when we had the terrible terrorist attack by Hamas. Between 7th of October and then 31st of December 2023, so last year, more than 200 removal orders were sent targeting specific content related to the attack in the Middle East. And that really helped to reduce the terrorist content that related from the attack to staying online, to spreading, to disseminating, to traumatizing individuals as well. And What's different here to the DSA is also that there's quick removal. So under the TCO, you have to remove terrorist content within 1 hour only. And that's not only a big difference, but it's also key for the terrorist content online regulation, because we see the longer terrorist content can stay online, the more it can inspire others, it can radicalize others, it can traumatize vulnerable users. So for example, when we had the terrorist attack that was live streamed in Christchurch in 2019, we saw that this content stayed up a lot longer than 1 hour, and that content really has led to inspire other attacks. So we had seen copycat attacks afterwards, and it still does inspire others, and there's still copies online. So really removing terrorist content within 1 hour, which is a key aspect of the terrorist content online regulation, helps us to prevent that the content stays online and then is spread and disseminated widely and basically stays on the internet forever.
Thanks a lot. And what is the DSA perspective on this, Martina?
I absolutely agree with Friederike's points, and yes, absolutely, the TCO and the DSA work because they work together. The DSA, so the Digital Services Act, is an overarching framework regulation with the aim of making the digital services a safer place and to protect fundamental rights. So while the TCO goes into much more detail into the specificities of terrorist content, the DSA was created with the aim to harmonize the landscape, the regulatory landscape, both on a EU level and on a national law level, since we saw a lot of different initiatives coming or growing from the different member states. The DSA entered partially into force in August 2023. And was only fully entered into force in February 2024. With the DSA, we managed to harmonize certain due diligence obligations and liability exemptions. Or what the underlying importance or building block of the DSA is the fact it takes a risks-based approach. It looks specifically at systemic risks. So risks that really have the power to influence and shape the European Union. So on one side is obviously the dissemination of illegal content, under which also terrorist content falls. But then we also look at other risks, such as the risk of disinformation or democratic processes, for example, or the protection of minors, physical and mental well-being, for example, as well as gender-based violence. So as you can see, there is really just a difference in, let's say, level of concreteness, and in a way the DSA is more abstract because it tries to create an overarching framework for lex specialis.
Thank you. Both regulations come with specific obligations for online platforms. What are the main obligations posed by the TCO regulation?
Yeah, so I think we can have 5 main obligations for the hosting service providers here. The first one is quite obvious. That is to remove terrorist content within 1 hour after receiving a removal order or blocking the content in the EU. I think that's also important to say that if the company blocks the access to the content in the EU, then it's also complying with the TCO regulation. The second, and I think this is equally important, is that the company, when it removes or blocks the access, has to preserve the content for up to 6 months. And that is key from a fundamental rights perspective, because if it turns out later on that the content has been removed unduly, the company can reinstate it. And or if the content and the scenario around it is investigated by law enforcement can then access the content later on and use it in investigations. The third obligation, also I think very important and from a fundamental rights perspective and important for our users and listeners here, is the transparency reporting obligations. And that means that not only the hosting service providers, but also the competent authorities have to provide annual transparency reports on the content they removed, on the complaints they received, on the content they reinstated, and the outcomes of these procedures. So really that we all know what's happening. The fourth obligation, something that I just mentioned already, refers to user complaints. So companies need to make sure that users can complain if their content is removed. And then they also have to follow up on this. So really protecting our fundamental rights. And then the fifth big obligation that I want to mention is that companies have to take specific measures if they are declared as being exposed to terrorist content. And that means they really need to take specific steps to prevent that their platforms are exploited by malicious actors. And I think important here to note, because this is a question that we receive quite often, is that these specific measures can be automated tools, but they don't have to be. And if they're automated tools, then we need to ensure human oversight. So again, really strong obligations here to protect fundamental rights.
And how is it about the DSA? What are the main obligations there?
As we've seen before, the DSA is a bit of a larger framework, so it also applies to very different services. And the DSA tries to take in consideration both the size and the type of service that we're looking at to really impose obligations that are proportionate to the size and to the means of the company. We have a number of different obligations that are, for example, transparency obligations. So that is quite similar to, for example, what also the TCO has. Let's say these transparency obligations there as well, they are different according to the size of the companies and of the service. Some have just have to, for example, say what kind of content they moderated, while others, bigger companies, will have to state how many human moderators, for example, are included in the process. We then have a number of obligations supporting user rights. So on one side, we have the notice and action mechanism, for example, which enables users to report illegal content to the platform. We have we have provisions for data access, which should help researchers and academic institutions to get access to data, which then can also help their research and in turn our enforcement work. But we have also other obligations in relation to the protection of minors, for example, so about addiction, about dark patterns, for example, in services. So there is really a wide variety of obligations. And I don't want to talk before the next question because I know we're going to talk about it a little bit more. However, yeah, they depend a lot on the size of the companies and of the services themselves.
The tools and mechanisms included in these regulations are crucial to ensuring their effective implementation. Could you walk us through the main tools? Let's maybe start with the TCO regulation again.
Of course. The TCO, as I said at the beginning, is a lot more of a specialized instrument. So we also have, I would say, specialized tools. The main tool really is the removal order. So that is an order that a hosting service provider can receive or will receive from the national competent authority of a member state. And that basically lies down the information of what is the content, why is it considered terrorist content, and with the request to remove or block access within 1 hour. And this is the tool that the TCO is built on. I think important here to say is that the referrals, which are voluntary, can still take place. So they're not necessarily a tool under the TCO, but they're also not made redundant by the TCO. And then something I mentioned earlier, which I think we can describe as a tool as well, are the specific measures. So if the company is exposed to terrorist content and then is notified as being designated as exposed to terrorist content by the national competent authority, companies have to apply these specific measures. And the regulation does not define what these measures look like. They give some examples, but I think it's important here to understand that the level of expectation and also the measures that the companies take should be appropriate to the exposure to terrorist content, to their size, their capabilities, and their resources. But these two are really the big tools that we have under the TCO regulation, or the member states, better, so to say.
Martina, how does the DSA differ in terms of tools and mechanisms?
I think there is one very big commonality that is in relation to the removal orders. So we provide the framework for it, and then the TCO has, let's say, the underlying, the substance. Other than that, we have the risk assessment and mitigation measure report, which is for, let's say, the largest platforms out there. We have also, I already mentioned before, the notice and action mechanism and the appeal system for users, which enhances user rights. However, we then also have a trusted flaggers, so civil society organizations that have a special expertise in a certain area can apply to become trusted flaggers to flag a certain type of illegal content. It can, of course, also be terrorist content. We have also recently developed a whistleblower tool, which allows people and also ex-employers of digital services or employers or current employers, employees of digital services to upload documents or any kind of underlying data that I think would be useful for our enforcement. And through this whistleblower tool, it can be done anonymously, or also like personal information can also be provided in this case. Besides these, let's say, tools that are focused on digital services and what they have to do or what they can do, and what they on external partners, the Commission and the digital services coordinators, so the national authorities enforcing the DSA in each member state, they also have a variety of enforcement tools. From the Commission side, we can open proceedings against the very large online platforms and search engines. We can send requests for information. We can organize or schedule interviews and inspections in the digital services. And then we can also, if we find a suspicion or we find a non-compliance for one of the different obligations in the DSA, we can also negotiate commitments with these different digital services, or we can apply interim measures or fines. For example, we have already had the first commitment decision under the DSA with TikTok some weeks ago. It's not on terrorist content, but more related to the protection of minors and TikTok Lite. That is not going to be rolled out in the EU anymore.
And maybe if I can complement with one thing, because I have, as Martina has spoken a lot about but one big difference, I think, between the TCO and the DSA is that under the TCO regulation, it's the member state actually who have the tools at their disposal. So it's not the Commission. And under the DSA, of course, that depends on the platform size, but it's a little bit of a difference. So under the TCO, the member states have the tools at their disposal and not the Commission itself.
You both just mentioned the national authorities. Are these the same for both regulations?
That's actually a very good question. In most cases, they're not, and they don't really have to be. Under the TCO regulation, for example, there can be different authorities for the different tasks that they have. And the Commission has published the list of national competent authorities and their contact points as per regulation. So if you Google this list of national competent authorities and contact points, you find it on the DG Home website from the European Commission, all the different authorities per member state for the TCO regulation. And then you can actually, even if you want to, compare to if this is the same or a different authority under the DSA. But I guess Martina can say more to the competent authorities under the DSA.
How are the authorities organized in the DSA?
Under the DSA, we have designated digital services coordinators, which are the competent authorities, or let's say our counterpart, the Commission's counterparts in each member state. They were appointed in February this year, and they have all, let's say, enforcement powers against all the smaller platforms. And they are also the ones that should be in contact with, for example, civil society in each member in their own member states, or with law enforcement agencies to when it comes to different orders and different communication and processes that are established under the DSA.
What impact do both regulations have on small versus large online platforms, and more generally, which platforms and online services are in scope? To start off, how is it with the TCO regulation? I think it sets out a broader definition, right?
Yes and no, but I actually maybe start with the definition and then go back to who's covered. So the TCO regulation applies to hosting service providers. I've used the word quite a lot now, and probably also sometimes the abbreviation HSPs. And an HSP, a hosting service provider, is a company or like a service if it qualifies by fulfilling 3 cumulative criteria. And that's firstly, that the content has to be stored at the direct request of the user. Secondly, the content is disseminated to the public. And thirdly, that the service is offered in the EU. So any online service provider who fulfills these three criteria is considered an HSP under the regulation. And interesting here is that it can be also a part of a service of one platform, while other services of the same platform are excluded. So, for example, if content is shared on the general, let's say, Facebook feed, it is covered by the TCO regulation because it is disseminated to the public. But if the content is, for example, shared in a closed group where a user decides on who has access to the group or not, then it might not be covered because the criteria of dissemination to the public is likely not to be fulfilled. Important here again, it's not the Commission that interprets the regulation. It's up to the member states and eventually the European Court of Justice. But just to say that it's not necessarily the full platform, but only specific service. And then to your first part of the question, the differences for small versus large online platforms, here the answer for the TCO is quite simple. And it's very different to the DSA because for the TCO, there are no additional responsibilities related to the size or the reach of the HSP.
In contrast, the DSA differentiates several levels. Could you explain to us how the DSA impacts platforms of different sizes?
Yes, absolutely. I think this is a really big big point to understand how the DSA functions and how it's also is enforced and is supervised. So, as we say, the Digital Services Act, obviously, it applies to digital services. That means all online intermediary services, including online platforms, so online marketplaces, social networks, app stores, but also cloud services, web hosting services, and other similar platforms. We then, besides like this very broad categorization of digital services, we then have a differentiation when it comes to their obligations and to the enforcement powers as well between the Commission and the member states. The biggest difference is when a online intermediary reaches 45 million monthly active users. Once they reach 45 million monthly active users for at least 6 months in a row, platforms can be designated services. So that is when designated services are then called very large online platforms or very large online search engines. So that includes currently, I think, 22 or 21 platforms, and includes obviously social networks like Instagram, Facebook, but also Booking.com, for example, obviously the app stores. That is, let's say, the biggest difference. And that's also where obviously they're very large online platforms, we call them VLOPs. They obviously have a higher burden of obligations. They are all under Section 3 of the DSA for all the lawyers listening to this. And it starts with the obligation that very large online platforms have to undertake a risk assessment. Every year they need to assess the risks related to 4 categories of systemic risks in the EU. As I mentioned before, the ones related to the dissemination of illegal content, democratic processes, disinformation, protection of minors, and others along these lines. And they not only have to assess whether these risks appear on their platform and in what size and in which ways, they also have to implement mitigating measures. Mitigation measures can mean very different things. So it could mean on one side just an adaptation of the terms and conditions, for example, of the service, but it can also mean adapting the recommender systems, for example, to mitigate certain risks. So it has a very, very big variety of degrees. The Commission enforces and supervises these designated platforms, while the digital services coordinators, the DSCs, are the ones looking at all those digital services that are located in their specific member states. Here, for example, we see obviously the Irish DSC having a particular role because a lot of the big companies are a lot of digital services are based in Ireland. But as I'm sure you know from your personal life, there is a lot of smaller online marketplaces in all the different countries that also would be digital services. And that's where the DSCs step in.
Fairness and accountability in content removal are key in both regulations. What mechanisms are provided under the TCO regulation to ensure that content removal or service restrictions are done fairly and transparently?
You're right. That's a really important question. Under the TCO regulation, I would say we have 4 key provisions to ensure fairness and accountability and to safeguard fundamental rights. Firstly, in the case of a cross-border removal order, this means when a company receives a removal order from a national competent authority other than those where the company has its legal establishment, the host national competent authority has the right to scrutinize the removal order as its own initiative within 72 hours. So there's really a checks and balance between the member states, so to say. Secondly, and I've touched upon this earlier a little bit, a user can complain to the company if his or her content has been removed as a result of a specific measure. And then the company has to assess this complaint and inform the user of the outcome. Thirdly, the company can also disagree with the removal order because the assessment if something is terrorist content or not is taken by the competent authority. So in case the company disagrees with the removal order, it has to, and I think that's important, it first has to remove or disable access to the content, but then it can challenge the validity of the order in front of the court. So again, we have really the judicial oversight here. And then lastly, the TCO regulation requires transparency from companies and from national competent authorities alike. So both have to publish annual transparency reports on the activities that they take under the regulation. That not only includes the number of removal orders issued or received, but also information on the complaint procedures, reinstatements, and then the reasoning behind these actions, so that everyone can publicly see what's happening and why has it happened and what was the outcome.
How is it with the DSA? How are fairness and accountability ensured there?
On the DSA side, we have also 4 different points to address this issue. So first of all, any content moderation decision taken by a service has to be notified to the user. So whenever a content moderation decision is taken, the user can then make, if it doesn't agree, for example, it can make an internal complaint and request a review of this decision. In case he is still not yet, the user is not yet satisfied with the result of this internal complaint, there is also another step of escalation with the out-of-court dispute settlement. I think so far we have 2 out-of-court dispute settlement bodies that are appointed under the DSA in an attempt basically to reverse or to discuss the different, the content that is being removed. Whatever the decision is, the companies, the digital services have to provide a specific statement and a specific also reason for why they have removed certain content, and also reinstate it in case either the internal complaint has a different outcome or the out-of-court dispute settlement body also does. Additionally, the DSA, or there is a publicly available statement of reason database where all digital services, and actually not only, I think all digital services, yes, so not only VLOPs, but also smaller platforms can send in all the content moderation decisions taken. So you can also filter, for example, by grounds, you can filter by time, so by dates, for example. We've actually seen already this has been very useful also for the enforcement work because a lot of research is being done thanks to these statements of reason database, for example.
Finally, especially for smaller platforms, it can be challenging to keep track of the developments and different obligations laid on them. Are there any tools, frameworks, support systems offered by the EU to assist platforms, small platforms in particular, in navigating these regulations? Friederike, do you have recommendations for us regarding the TCO?
Yeah, of course. So as Commission, we are of course aware of the particular challenges that new regulations can create, especially for smaller companies that maybe don't have so many resources that can help them to implement it. So we support from our side the platforms in 3 different ways. Firstly, we invite companies to join the EU Internet Forum. As I mentioned earlier, that's our well-established public-private partnership, where we work together with industry to support them in their efforts to prevent the spread of terrorist, violent extremist, and borderline content online. Borderline content, just as a small break here, we define as the content that is from a terrorism perspective legal, but it is still harmful and can lead to radicalization. And our support here can take the form of concrete products to help content moderation, to facilitate contacts with other companies, and also with law enforcement, or to inform about developments at EU level. Looking at the TCO regulation then specifically, under the Internal Security Fund, we funded 3 projects, among them Tate, from which this podcast is, to support small HSPs in navigating and implementing the TCO regulation. For example, by having events, developing tools, sharing information. The webinars also, which are often recorded, can be of help, or the training program. So I think I said it the last time as well, I really recommend all listeners to check out the 3 projects. And then many of the actors involved in these projects, such as Tech Against Terrorism or TREMO, also have additional tools and guidance to form and to inform small companies about the obligations under the regulation and help them then to implement the regulation. And then lastly, so the third way of how we support companies, especially small ones, is that we organize TCO workshops with the member states and companies where competent authorities and the companies can discuss practical questions related to the implementation. And that so far has been really a great success because, there's a direct exchange between the competent authorities and the companies, and really sometimes nitty-gritty but very practical questions can be addressed. And we have found this and the companies as well quite helpful until now.
And finally, Martina, what would you recommend related to the DSA?
Besides the publicly available information, so on our website, for example, the Q&A website, or even our specific websites for information for businesses and citizens, they describe pretty well, in a more easily understandable way, all the different changes that the DSA requires. When it comes to smaller platforms, they are usually under the responsibility of the DSCs, so the national member state authorities. And they can always reach out to the DSCs to know more. Other, let's say, awareness-raising initiatives that we have is obviously, also this podcast. So being here, talking to different stakeholders, whether it might be also academia, for example, or other platforms, we're always happy to engage and give answers to the different players.
Also, actually, if I can come in one time again, there's another thing or 2 other things that came to my mind, actually, because some of the national competent authorities also have been really active and developed additional guidance. So, for example, the German competent authority has published a study informing about good practices of potential specific measures that companies can take to prevent terrorists' exploitation of their services. And then also the EU Internet Referral Unit, which sits in Europol, is really open to work with online service providers that want to address the dissemination of terrorist or violent extremist content on their platform. So really, there's a wide array of support for small HSPs, from training to practical support. I really recommend to check out also Europol and the national competent authorities, which you find in the list of national competent authorities that's published, and which I'm sure we can publish the link in the show notes.
Definitely. Thank you so much, Friederike and Martina. I think we had a perfect duo here for helping us navigate the similarities and differences between the TCO regulation and the DSA. While these regulations have distinct goals, they crucially work together to create a safer and more accountable online space for everyone. To our listeners, I hope you found this episode as insightful as I did. Whether you're a platform operator, policy enthusiast, or just curious about digital regulations, there's also plenty more to explore and a lot of resources provided by the European Commission, so make sure to check out the links in our show notes. Thanks for tuning in. Take care, everyone. Goodbye.